Hi friends, today we are talking about the case law of Berubari Union 1960. This case law depends on India-Pakistan border issue. Okay, before going to the explanation of the case law, first let's talk about the summary of the case law. Sir Redcliffe, chairman of Indo-Pak Border Commission, reported an award to find out the border to West and East Bengal, and that award was announced on August 15, 1947. According to that award, Berubari Union treated and governed as Indian territory until Pakistan raised the issue that Berubari belonged to East Bengal, mistakenly treated as West Bengal territory. So, two countries agreed an agreement to give half of Berubari Union to Pakistan without taking the terms of the Redcliffe Award into agreement. Then this case began and lastly agreed to give half of Berubari Union to Pak by an amendment of Article 368 of the Constitution of India. This is the summary of the case. Okay, let's go to the prefix of the case. On July 18, 1947, the British Parliament passed the Independence Act 1947. This act came into force on 1947 and which was called as the appointed day. As from the appointed day, the India was said as India and Pakistan. Okay. According to subsection 1 of section 3, Bengal was divided as East and West Bengal. Subsection 3 of section 3 says that a boundary commission is appointed to determine the boundaries of West and East Bengal, and the chairman of the boundary commission is Sir Redcliffe. The province of West Bengal is now known as the state of West Bengal, is a part of India, whereas the province of East Bengal has become a part of Pakistan and is known as East Pakistan, and now it is known as Bangladesh. So far, the Bengal was concerned, and material terms of reference for boundary commission should demarcate the boundaries on basis of non-Muslim and Muslim people area living there. In doing that, it means here the border commission has to consider other factors also. The commission held its inquiry and made an award 3 days before appointed day, and that award is known as Redcliffe Award. Here, award means giving the boundaries to West and East Bengal according to the Act. For this demarcation, he made 7 basic questions which depended. Question number 6 is relevant to our purpose. And what is question number 6? Question number 6 states, claim ought to prevail in respect of the districts of Darjeeling and Jalpaiguri, in which the Muslim population amounted to 2.42% of the whole in the case of Darjeeling and 23.08% of the whole in the case of Darjeeling, but which constituted an area not in any natural sense contiguous to another Muslim area of Bengal. It means some areas which were in this border issue has to be divided. That areas of Darjeeling and area of Jalpaiguri is not related to any Muslim area according to their traditions or culture. So, it appears that the member of the commission was not able to arrive conclusion to major issues, and so the chairman had no alternative but to proceed to give his own decision. Proceed with his own decision. So, this is the prefacts of the case. Let's go to the facts of the case. The main objects of this case law were Redcliffe Award and Nehru Agreement. And the award is Redcliffe Award. I can explain this with the help of map. This is called as Berubari Union. Berubari Union means It is a union of Coach Bihar, some part of Coach Bihar, Dimla, Boda, Pachgar Sadar, and some areas, Jalpaiguri. All these areas together form the Berubari Union. Let's go to the award. I will explain the award by this map. Okay. First, observe the boundaries of this Berubari Union. This is Assam. Here it is West Pakistan. It is Jalpaiguri area. It is Darjeeling. And this is Coach Bihar area. And this is West Bengal. This is West Bengal area. Okay. According to the award, it is provided that a line shall be drawn along the boundary between the Thana of Panishwada in the district of Darjeeling. It means the borderline has to be drawn from the Panishwada in the district of Darjeeling. It means here, from here. And the Thana Tetulia in the district of Jalpaiguri from the point where the boundary meets the province of Bihar, and then the boundary between the Thanas of Tetulia and Rajganj. This is the Thana of Tetulia and this is Thana of Rajganj. A border has to be drawn between these two areas, and then the Thana of Pachagar and Jalpaiguri. This is Pachagar. This is Pachagar and this is Jalpaiguri. And then shall then continue along the northern corner of the Thana of Debiganj to the boundary of the state of Coach Bihar. This is called as Coach Bihar area. We have to go to the north corner of Debiganj. This is Debiganj, north corner is here. And then this borderline continues according to the award. This is the borderline to West and East Bengal. The district of Darjeeling and so much of the district of Jalpaiguri as lies in north tourist line belong to the West Bengal. But the Thana of Patkiram, any other portion of Jalpaiguri district which lies to the east of this line shall go to the East Bengal, that means East Pakistan. This is the award. According to this award, there is an exchange of enclaves. Okay, let's talk about the enclaves. Here, enclaves of India are in pink color, enclaves are in Pakistan in green color. The Coach Bihar from the province of West Bengal and merged to West Bengal. From together, Coach Bihar is treated as part of West Bengal and governed as West Bengal. It appears that certain areas which formed part of the territories of the former Indian state of Coach Bihar and which has subsequently become a part of the territories of India and then of West Bengal become after the partition enclaves in Pakistan. Similarly, certain Pakistan enclaves were found in India. It means these green color enclaves all belongs to Pakistan, but after dividing the West and East Bengal, these enclaves all remained in India, but they are belongs to Pakistan, and our enclaves remained in Pakistan, but they belong to us. So they made an agreement to change these enclaves. This is the story of enclaves. Okay, let's go to the facts of the case. Subsequently, certain boundary disputes arose between India and Pak, but no issue raised about Berubari Union until 1952. In 1952, the question raised by Pak government. According to Awad, the Berubari was part of East Bengal and mistakenly treated as West Bengal. This subject remained until 1958. It is as under these circumstances the present agreement was made between two PMs of Pakistan and India in September 10, 1958. It appears that certain areas which formed part of the territory of the former Indian state of Coach Bihar and which has subsequently become part of the territories of India and then of West Bengal become after the partition of enclaves. This is all about the enclaves we have already explained. Then we are coming to the Nehru-Noon Agreement. Then Pakistan raised the issue of Berubari Union. The Prime Minister of India and the Prime Minister of Pakistan made an agreement that is also known as Nehru-Noon Agreement. Okay, let's talk about the Nehru-Noon Agreement. This agreement is also called as India-Pakistan Agreement. In this present agreement, we are concerned with the two items of the agreement, that is item number 3 and item number 10 in the agreement. I am explaining the agreement with the previous map. You shall understand better. First I will read the agreement. Berubari item number 3 in the agreement, that is Berubari Union number 12. This will be so divided as to give half the area to Pakistan, the other half adjacent to India, being retained by India. The region of Berubari Union will be horizontal starting from the northeast corner of Debikan Stana. It means the division will be horizontal. This is different what said from award. It means agreement is different from the award which was given by Sir Redcliffe. Here says a horizontal line has to be drawn to the northeast corner of Debikan Stana. This is the Debikan. This is the northeast corner, and a horizontal line have to be drawn from here. So, by this agreement, we think that this is much more part was going to Pakistan when we compared this agreement to the award which was previously given. Okay. And then the division should be made in such a manner that the Coach Bihar enclaves between Pashagar Thana of East Pakistan and Berubari Union 12 of Jalpaiguri Thana of West Bengal will remain connected as to present with Indian territory and will remain with India. The Coach Bihar enclaves lower down between Boda Thana of East Pakistan and Berubari Union number 12 will be exchanged along with the general exchange of enclaves and will go to Pakistan. And similarly, item number 12 deals with exchange of old Coach Bihar enclaves, old Coach Bihar enclaves in Pakistan, enclaves in India, without claim to compensation for extra area going to Pakistan. This has to be agreed. Okay, we are explaining these two. Let's go to the issues of the case law. The issues of the first issue are whether the agreement, means Nehru-Noon Agreement, is to ascertain and determine the boundaries in the light of award. It means the actual construction of the agreement is to ascertain and determine the boundary of East and West Bengal or any secession of Indian territory is included. The second issue is, if not, then Parliament has any power to implement it. It means agreement. It means if this agreement is not about to ascertain and to determine, then this agreement is implemented or not. The third issue is any legislation action necessary for the implementation of agreement relating to Berubari Union and exchange of enclaves. If so, is it related with Article 3 of Constitution or any amendment of the Constitution in accordance with Article 368 of Constitution is necessary. These are the issues of the case law. We can go to the judgment of the case. On behalf of the Union of India, the learned Attorney General argues that no legislation action is necessary for agreement relating to Berubari Union and exchange of enclaves. In regard to Berubari Union, he argues that this agreement is to ascertain and determine the exact boundary about a dispute existing between two countries in the light of award, but it is not an alienation or cession of any territory of India. He also argues that exchange of Coast Bihar enclaves is a part of the general and boundary agreement about the Berubari Union. He also said that agreement can be implemented without any legislation action. For this, he relied on certain provisions. They are Article 253, Article 245, Article 246, Article 248, Article 51, 73 and 74. These articles mostly related to the powers of Parliament to make any law, to acquire or cession of any part of Indian territories or others in favor of foreign country. Okay. Then we go to the further judgment of the case. But as we refer to the item 3 of the agreement, it is difficult to accept the argument that this part of agreement amounts to no more than ascertainment or determine the boundary in the light of the award. The agreement is clearly purported to give half of the dispute area to Pak. It means to cede a part of Indian territory. We also deal with another argument made by the learned Attorney General. He contended that the implementation of the agreement in respect of Berubari Union would not necessitate any change in the first schedule of Constitution because according to him, Berubari Union was not mentioned in the said schedule. But since the award, Berubari Union was treated as the west part of West Bengal and governed as like it. Therefore, as a result of the agreement, the boundaries of West Bengal and the content of the first schedule would be affected. At this stage, it is necessary to consider the merits of the rival contention raised by Mr. Chatterjee before us. He argues that even Parliament has no power to cede any part of the territory of India in favor of a foreign state, either by ordinary legislation or even by the amendment of the Constitution. So, according to Mr. Chatterjee, the only opinion is the agreement is void by any legislation process. This is another agreement by Chatterjee. When we go this, Mr. Chatterjee taken reference the very first sentence in the preamble which declares, "We, the people of India, having solemnly resolved to constitute India into a sovereign democratic republic." That India geographically and territory must always continue to be democratic and republic. Okay. He also refers to Article 1, which says that the territory of India shall comprise such other territories as may be acquired. So by all these, the constitution given the power to country to acquire any territories, but has no power to cede any part of its territory. This is the argument of Mr. Chatterjee. But according to this case law, preamble is not treated as a part of the constitution. So we put preamble aside and go to the construction of the Article 1, Clause 3, Subclause C. It is erroneous to assume that it confers specific powers to acquire foreign territories. The other answer to this contention is provided by Article 368. That article provides for the procedure of the amendment of the Constitution and confers powers to Parliament. The power to amend Constitution must inevitably include the power to amend the Article 1, and that logically would include the power to cede any national territory in favor of a foreign state. So we must reject Mr. Chatterjee's contention that no legislation process can validate the agreement in question. Okay. Then the question is how treaties can be made and exercised in matter of cession of national territory. Stated broadly that whether the treaty made can be implemented by ordinary legislation or by amendment of Constitution will naturally depend on the provisions of Constitution itself. Then go to the further judgment. For this it is urged on behalf of the Union of India that Article 3 of Constitution is sufficient for implementation of the agreement of law of Parliament, and if that be so, there would be no occasion to treat any action under the Article 360 of Constitution. The argument is going on, and for another argues that for the first we have to understand the construction of Article 3. So they are saying that the agreement can be done on the legislation action under Article 3. Then we have to know what is Article 3. The Land Attorney General says that the makers of Constitution were aware of the peculiar conditions under which and the reasons for which the states were formed and their boundaries were defined, and so they deliberately adopt the provisions of Article 3. So according to the fact, we have to know what is in Article 4 before constructing the Article 3. Okay, what is the effect of Article 4 in Article 3 and 2? The effect of Article 4 is that the laws related to Article 2 and 3 are not to be treated as constitutional amendments for the purpose of Article 368, which means that if legislation is competent under Article 3 in respect of the agreement, it would be unnecessary to invoke Article 368 and vice versa. The crux of the problem, therefore, is can Parliament legislation in regard to the agreement under Article 3 or not? Okay, let's talk about the principles of the case. The principles involved in this case law are Article 1, Article 2, Article 3, Article 4 and Article 368 of the Constitution. First of all, Article 1. Article 1, Subclause 1. India, that is Bharat, shall be a union of states. The states and the territories thereof shall be as specified in the first schedule. The territory of India shall comprise, then go to the Article 2, admissions or establishment of new states. Parliament by may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. The most important article in this case lies Article 3. Then go to the Article 3 Clause A. Article 3 Clause A states that form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory of a part of any states. It enables Parliament to form a new state, and this can be done either by the separation of the territory from any state, or by uniting two or more states or parts of states, or by uniting any part of the states. Thus, Article 3 Clause A deals with the problem of formation of new states and indicates the modes by which a new state can be formed. And Clause B says increase the area of any states. Provides that a law may by pass to increase the area of any states. This increase may be incidental to the reorganization of states, in which case that what is added to one state under Article 3 Clause B maybe have been taken out from the area of another state. The increase in the area of any state contemplated by Article 3 Clause B may also be the result of adding to any state any part of the territory specified in Article 1. So, Article 3 Clause D says that refers to the alteration of the boundaries of any state, and such alteration would be consequence of any of the adjustments specified in Article 3 Clause A, B or C. And Clause E, alter the name of any state. This is not related to this case. Then go to the Article 3 Clause C. It is the ozone related to the case to get answers. Okay. It is significant that if an increase or diminution in the areas of Union territories is contemplated, or the alteration of their boundaries or names is proposed, it cannot be affected by law relatable to Article 3. Article 3 Clause C deals with the problems of the diminution of the area of any state. But Article 3 refers to the case where a part of the area of state is taken out of the state and it is not added to any other state but is handed over to foreign state. This is not mentioned here, Article 3. The land attorney contends that the words used in the Article 3 Clause C are wide enough to include the case of the cession of territory in favor of a foreign country. We are not impressed by his argument. So we have to go to the further. Article 3 Clause C to hold that by implication it provides for cases of cession of a part of national territory. Therefore, we feel no hesitation in holding that the power to cede national territory can't be read in Article 3 Clause C. There is another consideration that Article C does not refer to Union territories. If any secession, the question is, if any secession of Union territory would inevitably have to be implemented by legislation relatable to Article 368. But it is unreasonable that whereas the secession of a part of Union territories has to be implemented by legislation only related to Article 368. In this connection, the learned Attorney General has drawn to the provision of the Act of 1951 by which the boundaries of the state of Assam was altered consequent on the secession of an territory comprised in that state to the government of Bhutan. He has only cited this as an instance where the Parliament has power to effect the secession of a part of the territory of Assam in favor of the government of Bhutan by enacting a law related to Article 3 of Constitution. We do not think that this instance can be of any assistance in constructing the scope and effect of the provisions of Article 3. Therefore, our concern is it would be no competent to Parliament to make a law related to Article 3 or for implementing agreement. So the agreement has to be passed under Article 368. we already deal with Article 4. Then going to the Article 368, Clause 2. An amendment on this construction may be initiated only by the introduction of a bill for the purpose in either House of Parliament, and when the bill is passed in each House by a majority of total membership of that House, and by a majority of not less than the 2/3 of members of that House and voting, and it has been presented to the President for his assent, and upon assent being given to bill, the Constitution shall amended by terms of bill, like Article 54, 55, 73, 162, 241, and Chapter 4 of Part 5, Chapter 5 of Part 6, and Chapter 1 of Part 9. Any list in the 7th schedule, representation of states in Parliament only. So these are the principles which included in this case law. Then going to the conclusion. What is the conclusion of this case? Is that in this connection it may be incidentally be pointed out that the amendment of the Article 1 of the Constitution consequent upon the cession of any part of the territory of India in favor of a foreign state does not attract the safeguard prescribed by the proviso to Article 368, because neither Article 1 nor Article 3 is included in the list of entrenched provisions of the Constitution enumerated in the proviso. It is not for us to inquire or consider whether it would not be appropriate to include the two articles under the proviso. That is the matter of the Parliament to consider and to decide. So the answers of our issues, we are currently discuss about the issues. So when we have to go to the answers, okay, the first question is whether the agreement, Nehru-Noon agreement, is to ascertain or determine the boundaries in the light of award. No, it is not to ascertain or determine. It is to secession of a part of Indian territory. So the answer is no. Question 2. If not, then Parliament has any power to implement? Yes, the Parliament has power to implement that agreement. Third question. Is any legislation action necessary for the implementation of the agreement related to Berubari Union and exchange of enclaves? Yes, the action of legislation action is necessary. If so, fourth question is, if so, is a law of Parliament relatable to Article 3 of the Constitution sufficient, or any amendment of the Constitution in accordance with the Article 368 of Constitution is necessary? So, an amendment related to Article 368 is necessary. This is the case law. Hi friends, please like, share and subscribe our channel Nyaya Nivedika. We will come with more case laws and judicial pronouncements. Friends, like, share and subscribe చేయండి. మేము మరికొన్ని ముఖ్యమైన కేస్ లాస్ త్వరలో పోస్ట్ చేస్తాం. మీకు ఏదైనా ముఖ్యమైన కేస్ లాస్ మీద వీడియోస్ కావాలంటే కింద కామెంట్ సెక్షన్లో మెన్షన్ చేయండి. థ్యాంక్ యూ ఫర్ వాచింగ్.